Okay, it is Monday, April the 18th, 2022, and welcome to week number 3. That means we're at the end of this week. We will be done with the first half of the course. So I encourage you to get those assignments in. Of course, week 1 assignments, many of you did pretty well. Um, and one of the things that maybe some of you guys missed is that I said this in the first lecture, and I believe I said in the second lecture, that whenever you cite a case, whenever you mention a case, particularly major cases like the Fourth and Fifth Amendments, you do cite those cases, and I provided citations for you, I think, in the lecture. But it is very important that you get into that habit because that's the professional way of doing it. So you'll put the not just it'll have to be either as you don't have many assignments to do with PowerPoints here. I think the last assignment is also a PowerPoint, but week 5 um, is sometimes written as a PowerPoint, but I when we get to that I will deal with that. But your notes, those notes are very, very, very important. A few students had trouble getting those notes included, speaker notes I'm referring to, and that's the requirement that's in the assignment. So the syllabus, not the syllabus, but the rubric puts you in a category when you don't have them, and I have to check that box off. And then I remind you. But remember what I said, that whenever you do your assignments, always match up with the rubric. The same rubric that I grade with is the one that you see when you complete your assignment, the one that I share in each lecture. And so it's very easy to maximize your points by simply following that. And one of the big things is APA, citations in the body and references at the end. And then, of course, I run all your papers through Grammarly so that I can check to see if you had any critical thinking in there. So it's very important. I will be completing your week 2 grading by the end of this week, as I did with week 1. So, well, tonight is tax day. Hope you got your taxes all in if you're working. I usually wait till the last day. I did. I went to the post office earlier today. So um, get those taxes in. I was the victim this year of tax fraud. Someone filed taxes from an address that I used to live at 11 years ago. And they filed it for this year, this past year, 2021 taxes. And an SR, which is a senior form, but I never used that form. So the people that lived in the house that I sold to tipped me off, but the IRS also included in my account. So I called up and talked to an agent last Monday, a week ago, and got that all straightened out. But it's amazing. Uh, I said, I wish I was getting money back this time, but I wasn't. So, at any rate, get those taxes in by midnight tonight. If you're on the East Coast, it's 8:04, so you got about 4 more hours. If you're here, you got 5 hours. So, okay, let's get into sharing my screen, get into the topics for this week. All right. So let's go to the content page. All right. So I won't click on messages. This, of course, is the grade book. This is where I see these are some assignments. Some people, it says I got 4 to grade, but I know what that's all about. And discussion posts from last week. I will be finishing those out along with the written assignments. So this week, written assignment is search warrant exceptions. I provided you with some information to help you with that last week. As you recall, last week we dealt with the major topic of the exclusionary rule, one of our major tools of implementing the Fourth Amendment as lawyers. And um, the one of my favorite discussion posts was last week too. The one with the head in the refrigerator, which everybody should realize would be excluded because of the way that it happened. But that's actually based on a real case, believe it or not. So today we're going to talk about search warrant exceptions, which is the written assignment that will be due Sunday, 11:59 p.m. Central Standard Time. And then reasonable suspicion, we're going to just comment about that. That is the standard below probable cause that's used for the Terry stop, the stop where individuals stop briefly and then pat down searches can take place. And then, of course, your live classroom submission. So let's go right into the calendar. And again, making sure again that you see where we are. You see, we've come from a long ways from the fourth. We're 2 weeks into it. And so our live lecture is tonight. Your initial post is due tomorrow. And then your reply post due Saturday. And then, as I said, your live classroom lecture phrase, which Brenda, she's here, so you have a head start on that one. And then your written assignment that's due. And then we'll come back next Monday, and be aware that actually when we come back next week, that'll be the last week in this month, because you can see right here that that following week is the 2nd, that's 2 weeks from now, and that the course actually ends that following week on the 10th. All assignments have to be in. At the end of week 3, I will not accept assignments from weeks 1 to 3 unless you have extenuating circumstances. No one has shared with me extenuating circumstances. And please, as I remind you guys, I'm here to help you in so many ways. Don't hesitate. And the thing that I want you to be very much aware of is that there is no time when you can't call except the 25th hour of the day. And I would like to have emails as the last resort. But if you want me to know something like right away, you want to text me or call me, one or the other. And in case you forget the phone number is on the syllabus. So if you go to the syllabus, it is also on the where is it? It's someplace else too. But it's on the syllabus, and that's where you can get it. It's 630-660-8480, and just hit me up. All right. So the course actually ends May 10th, because on the 12 o'clock, which would be the 11th, term 2 starts. Okay, let's go back into constitutional law. Let's look at the announcements for this week. Let's pull that over here. And let's move that down there. So this week, the Fourth Amendment and government authority, and textbook chapter 9, I sent you the corresponding PowerPoint for the textbook. and dealing with Terry versus Ohio. I kind of referred to that earlier. And there were several other items in here that you're going to check as well. And so make sure you do those readings as well. This is the link, but you already know that if you're here. Discussion assignment is reasonable suspicion. Again, initial post due tomorrow night. That would be the 19th. And then Saturday, I'm sorry, 11:59 p.m. For the reply post. Then your written assignment, search warrant exceptions. We'll talk about that in just a few minutes, due Sunday. And I constantly remind you, and I say this again, and you know, some people say, well, I already know what he's going to say. I have to keep saying it because you trust me, I've been doing this. I've been at Rasmussen since 2011, I'm sorry. So I'm working on my 11th year in October. And there's at least one or two students might miss some of the things I say. So I'm keep trying to get this until I see a pattern that I don't have to do it. So far, I haven't seen that. So make sure you pay attention to what's in the Blackboard class module under the lessons tab and the rubrics, highlighted, the rubrics. I use those for your grades. I have students that say, I don't see any feedback. I said, yes, there is always feedback. Even if I didn't say anything, if you got exemplary, then I didn't say anything because you got everything right. But let's say you got less than that. I will tell you what you did wrong, and it will throw you into a category. And so you don't want to be in that last category, which I'll show you in a few minutes. So let's continue to be strong, finish strong. And my motto, adversity springboard to success, you know about that, because that is reflected in this announcement here, a little blurb about myself. Okay, now let's get into module 3. And let's start with the written assignment. Okay, here we go. So you got these various scenarios. You got 5 of them. 5 scenarios all together. And each one is going to be different. So what you're going to do is you're going to read the scenarios and discuss the applicable exception to the search warrant requirement. There is an exception. Again, I've provided you with some information, and then we're going to mention some more tonight as well. So you're going to look at each of these scenarios, and you're going to write about each one. Now, make sure you designate scenario 1, scenario 2, 3, 4, 5. It's going to be a 3 to 4 page paper. If it was me, I would balance my responses to be able to. So roughly, if you look at, you got 5 responses, and you might have maybe a half a page for each one, because that would be a half a page. That would be half a page. That would be 1. Half a page 2, and then 3. So or you might have 3/4 of a page, but you know what I mean. Make sure that you have at least 3 to 4 pages. Don't short one or the other. If you go over, that's okay. Don't worry about it. And so you're going to discuss the applicable exception. And if you say there is no valid exception, explain why there is not. Support with the appropriate case law. When you cite the case I just got through saying, please don't use OYES, don't use fine law. Use the official court citation. I've already told you how to do that. It starts out with a number, and then it goes US. I'm using United States Supreme Court because that's pretty much what you're going to use. And then the second number is actually, the first one is the volume. US, and then the next number is the page where the case starts, and then in parentheses next to it, the year that the Supreme Court or the court issued the decision. Now, you don't have to say that each and every time throughout the paper when you're citing one, but at least at the first time you should, and then appropriately cite it according to APA as well. All right. If you have any questions, set an appointment up with a tutor regarding APA, which you guys should be well aware of how APA works. You're getting ready to get your bachelor's, you're completing it for your bachelor's. So you want to make sure you're on top of that. You should be. Run your papers through Grammarly. Very important that you don't copy and paste information and try to throw in a little bit to make it seem like yours. It's not going to fly. It's going to get you a hit, and you could get into some trouble here. You do want to graduate. You do want to leave here with as higher grades as you possibly can. You want to gain as much knowledge. You do it by researching. Don't just use what's in the module. Don't just use what's in the text. I want you to demonstrate that you've provided other sources as well, and you know what the due dates are. All right, let's quickly take a look at the rubric. Okay, let's move this over here for now. Okay, so for each of the sections, you pay attention. Each of the 5 sections, and then credible sources in each section, by the way. There should be credible sources to cover each of it. Because remember what the purpose of credible sources or citations is. Citations in the body of the paper provide support for the statements that you include in the paper. It tells where you get the idea, the information, and that you're relying on to support your positions taken. Very important that you begin to think like that, because then a bulb should come on. And then, of course, a reference page. And the reason for this is so that individuals can read your papers who know nothing about the topic and be able to take that information, and you rely on what you provide them to go the next step. And that's how it's done. So you got to do that for each one. 3 to 4 pages. If it's less than that, it's going to fall over here. Okay? And but you can't have spelling errors and things of that nature. But look what it says here. And this is emerging. You don't want to be over here because it's 50% of the grade, which is failing. Professional language not used in a 3 to 4 page paper, or doesn't meet the 3 to 4 page minimum. Oh, but it's close. No, we don't work like that. With numerous errors that detract from the audience's ability to comprehend, that messes you up. Okay, so you don't want to be over here. No credible sources here. Here it says incomplete or incorrect discussion. I've already said this before to you, and I'll repeat it again. My definition of incomplete or incorrect discussion is failure to provide credible sources. You could have a good paper, but if you don't have those, you're going to end up in the column that's going to bring you to a 55 quite easily. So don't do that. So let's get back to where I do teach from, the mastery. And your outstanding means you've covered it in detail for scenario 1 through 5. And you have your credible sources cited in addition, and then it satisfies the 3-page requirement, minimum. Cover page, reference page as well. All right. Any questions? You can type in the chat box if you have questions. Excuse me. Okay. So I see nothing asked, so I presume there are none. All right. By the way, you can do this assignment more than once during the course of that period. That's why it says unlimited. And the final grade will be the highest grade. All right. So, but you want to try to get it right. But if you follow the rubric, I guarantee you, you will have it. Okay. The next thing is reasonable suspicion. And when you hear reasonable suspicion, the case that should pop into your head is Terry versus Ohio. That's the case should pop into your head. The old stop and frisk case. So in this discussion assignment, you're going to explore what reasonable suspicion is and its application to suspicious people and vehicles. And you're going to read this scenario here. And in your initial post, you're going to explain why you are able to stop John and his vehicle based on constitutional law. State it out in there. One stop, discuss what you would do next. Explain why you may be able, and that's a tip off, to frisk the interior of the vehicle too. Why you may be able to. Not all cases can you. Okay. And then in your reply post, reply to at least one other post. Okay. All right. So be aware that you cannot post until you see, you won't see the discussion post, and it's hidden until you post first. Again, the initial post is due Tuesdays and reply post due Saturdays. Your live classroom submission. This is where I will give you a word or phrase today, and click on the assignment, and then you put the answer in, and then it will come to me. All right. Your recording link doesn't mean much to you now because if you're here, you're already here, so you don't click on that. But what's going to happen is that after this lecture is over, I will clear this out and put in the link to the recording, and I will email it to you in kind as well. So we're going to talk about probable cause and reasonable suspicion first, followed by the Fourth Amendment warrant requirements, key terms for warrants, and then we'll deal with the exceptions and the common Fourth Amendment exceptions. Then there's a little knowledge check. There's a survey if you could do that as well. I know it's quickly, people say it's midterm already. Well, they always put it in there. You don't have to do it right away. No, it's not a requirement either. Okay. So let's talk about the first topic ever present. You remember from the very beginning of this course, I talked to you about the important amendments of the Bill of Rights, and today's focus is on the Fourth Amendment. And I said to you then, and repeat again, is that it is based upon searching, reasonable searches, and it requires the standard before you can conduct most searches. It says all searches, seizures, and warrants are based upon probable cause. So if it has to do with a warrant, it's going to require probable cause. Okay, so it says here ideally the courts would prefer a warrant before any search or seizure, but this is not a practical reality because most arrests and seizures are conducted without a warrant and based upon probable cause or supported by a common Fourth Amendment exception. If it's not based upon probable cause, then you will discover that that warrant can be cast away using a motion to suppress, which means that it cannot be used, the evidence cannot be used at trial. So we're going to talk about how the Fourth Amendment works. So here's just some basic language. And it says within the Fourth Amendment, no warrant shall issue upon probable cause, but upon probable cause supported by oath or affirmation. So what that means is that what a person has to do is to go before a judge, magistrate, to present an affidavit and testify under oath that they have probable cause to believe that there's crime taking place and that it involves an individual, if it's an arrest warrant, or to seek to search a location or place, then that is where they must also have an affidavit, unless the judge must approve it, unless it falls within one of the exceptions, which we'll talk about. So it's, somebody said it's a rather elusive term. Well, the courts and the cases have kind of delved into the application of probable cause. And because we operate, as you should know, on what we call stare decisis, that means that our previous cases decide the results of subsequent cases unless they're overturned, modified, or changed, one or the other. And they're changed by new court decisions that might affect the Constitution and or the new laws that are issued. Now, keep in mind that the Fourth Amendment began to apply to the states after the 14th Amendment came into being. Remember, we talked about this last week or week before that. So the 14th Amendment is the key to applying the first 10 amendments of the Constitution to the states and not just to the federal government. All right. So it talks about here that the facts and circumstances before the officer is given to a warrant, that a man of prudence and caution must believe that the offense has been committed is sufficient. So it's kind of like an average individual that might understand that some crime. In dealing with probable cause, however, as the name implies, it deals with what we call probabilities. They are not technical. They are based on fact and practical considerations of everyday life. So that what it says, as a reasonable and prudent person, not legal tactician. So it's based on the reasonable, prudent person. It's not based on lawyers, and it's not legalese either. I always say it's common sense. That's really what I always say it is. And one of my friends on the bench who's passed away, he said, "You're absolutely on it if you look at it from that perspective." All right. So an Illinois case that came about in '83, I remember this case well, dealing with probable cause, says there are not technical, not tactical, technical, nor are they factual, but they are fact. Boy, you're misstating, Richard. They're based on fact and practical considerations of everyday life, which a reasonable person, a prudent person, not a legal technician, would be involved with. So it's common sense. It's common sense. All right. So it's probably prudent to, if a person is walking around in an area and they're peeping in a window and it's night and the store is closed, that would possibly raise some probable cause. But because we are going to get into reasonable suspicion, you'll see where that is actually something that can be done. In other words, the person doesn't have to go get a warrant before they can stop the person, ask them some questions, pat them down, and so forth. Getting ahead of myself, but that's what we're going to come to in a minute. So probable cause is, as it says here, and the best way for me to say it is what they put it here real well, is the level of proof necessary for a law enforcement officer to make an arrest or support the arrest or search warrant. That's what they have to establish in front of the magistrate or judge, based upon facts, okay, circumstances, and available evidence. Could be made quickly, as it says, while the crime is in progress, and that's why we have exceptions. Could be long periods of time, and so forth. And now, if probable cause does not exist, the next standard is reasonable suspicion. It's either based on a warrant issued, or falls into one of the exceptions, or it's going to be reasonable suspicion. Those are the only three ways. Okay, I repeat that again. It's either going to be issued on probable cause or warrant, whether it's arrest or search, or it's going to be based on an exception to obtaining a warrant, or it's going to fall into reasonable suspicion. And reasonable suspicion is very limited. Okay. So now we got probable cause kind of nailed down. Let's talk about the old Terry case, Terry versus Ohio. And actually, from that citation there, it gives the name and it gives the year. But if you were going to cite the case, please include the volume number, the US, and then the page number in front of 1968. So it tells what happened. Is that, and this is a landmark, one of our landmark cases. It says that the Cleveland police detective who was he was in plain clothes. He noticed that two people were in an area downtown and he had not seen before. And so the detective had worked the area many years, and the detective could not precisely say what actually drew his attention to John Terry and Richard Chilton. But Detective McFadden noticed the people from a distance and observed Terry and Chilton walking 6 times from each side of the street, corner to corner, to peer in the window, just what I was talking about earlier, walk back to each other, confer, and walk back. So police is observing all of this. So finally, after they did it, it says the 12th time, the detective stopped them because he believed they were casing the joint out. Which, does that kind of make sense to you? Makes sense to me. And that he identified himself as a police officer and asked what they were doing. And, so Detective McFadden grabbed Terry, spun him around, and patted his exterior clothing. Okay. In Terry's left overcoat and breast pocket, he felt a pistol and he removed it. Now, McFadden also patted down the other person and found another gun in the overcoat pocket. At no time did McFadden reach into the clothing until the weapons were felt. And Terry and Chilton were arrested and charged with carrying concealed weapons. Okay. Now, the deal is that they wanted the attorneys for the defendants, Chilton and Terry, moved to suppress the evidence and said that because there was an unlawful stop So the trial court said, no, that's not true. This was a stop and frisk, and the difference between a frisk of outer clothing and a full-blown search. So the appeals court agreed with the state court. Ohio Supreme Court denied the appeal, saying that there was no constitutional question. So the United States Supreme Court agreed to hear the case and affirm the lower court's ruling. And so it was well established in that 8-1 opinion, which we hardly get now with the makeup of the court, established the well-known Terry stop, which is a tool used by law enforcement all across the country and has been codified in many jurisdictions in this country. And Justice Earl Warren, who was one of the liberal justices, provided the following direction to officers. And he made it quite clear in this language that is actually taken from the case, where it says, we're merely holding today that where a police officer observes unusual conduct which leads him reasonably to conclude in light of the experience that criminal activity may be afoot. That's a famous line we remember in law school, that crime may be afoot. And what that means is that a crime may be actively being involved or either getting ready to take place. And that the parties with whom they're dealing with could be armed and presently dangerous. So in the course of the investigative behavior, where a person identified himself as a police officer and makes reasonable inquiries, and where there's nothing initial stages of encounter to dispel their reasonable fear for his safety or her safety or their safety, they're entitled to the protection. And what they can do then is pat down the outer clothing in an attempt to discover weapons, not contraband at first, but weapons. And such a search is a reasonable search under the Fourth Amendment. And any weapon seized may be introduced into evidence against the person where we're taken. So the key thing is that the pat-down search was identified by Justice Warren to be able to protect the officers, so that the officers would, what do you do if you don't? Oh, we got to get a warrant. No, before we can take that gun. No, you get the gun because it's a dangerous weapon. It could be a knife as well. Okay, so there was no guidance about how long the search stop meant, but an average of about 20 minutes, many states, is what you want to remember. It's an average of 20 minutes, and that person can be checked out there. All right. Now, remember this, as I conclude this section here, is that a pat down, you see me, pat down of the exterior clothing may only reach and the officer may only reach into the clothing to remove what they believe is a weapon. It is a search and more intrusive than the frisk. So the frisk initiated, but actually upon discovering a weapon, then the officer is able to then take the weapon. So the Terry decision created what we call the reasonable suspicion. That's what I was referring to earlier as the necessary proof for a temporary stop, pat down, who may be potentially involving criminal activity. And after Terry, there's been a series of prodigy or cases that we say that came after that extended Terry to motor vehicles and permitted police to conduct a brief look into weapons were readily available, such as under the seat where the driver could reach it. So Minnesota versus Dickerson in 1993 approved the plain field, which, and that plain field, which I always thought was interesting, permits officers during a pat down to remove the suspect's contraband, which meant, yeah, that's when we started to get to the drugs and narcotics as well. Okay, so it's very important that you understand uh, how that works. Notice in these cases here, they include the full decision, but if you don't see it, go look it up and you'll be able to find it. By the way, you can Google it and it'll take you to it. All right. So that's probable cause and reasonable suspicion. That's something that you need to be definitely aware of. So let's talk about the Fourth Amendment warrant requirements. So the Fourth Amendment, as I already kind of alluded to already, so we can go through this pretty fast, is that you you have to, um, upon probable cause, go to a judge or magistrate and request a warrant. In order to get that warrant, your appearance in court supported by oath or affirmation and describing the place to be searched and the person or things to be seized. So whether it's a search warrant or an arrest warrant. And so the Fourth Amendment makes it quite clear that the rights of the people to be secure in their persons, houses, papers, and effects against unreasonable search and seizures shall not be violated, and no warrants, see, it mentioned warrants issuing, but upon probable cause, as we've said already, by oath or affirmation, and particularly describing the place and the persons to be seized. That's it. That's the Fourth Amendment. All right. Now, it does not prohibit search or seizures. Notice this. Rather, the Fourth Amendment prohibits unreasonable. See, that's where people got to make sure they put that word unreasonable in it. It's so critical. Sometimes their officers are placed in a situation where it's not practical for them to get warrants. That's when we will get to the exceptions in just a few minutes. But of course, though, in the normal course, the affidavit, which contains the facts to support the warrant, the judge reviews it, and if approved, issues the warrant. Okay. So it's a very important check and balance on warrants themselves. In other words, the police can't just do it. The judge has to issue it. And the affidavit must particularly describe the place and things that you're looking for. And it requires law enforcement to clearly describe the place and to minimize intrusion. The key thing is to make sure that the Fourth Amendment unreasonable search doesn't take place. Okay. In the old case, Marin versus U.S., the requirements of the Fourth Amendment that warrant shall issue describe the things to be seized, make the general searches under them impossible. So it's not just, oh, I think I just want to search, but it prevents the seizure of one thing under a warrant describing another. As to what is to be taken, nothing is left to the discretion of the officer executing the warrant. So the key thing is that the court will protect that individual. All right. And then these are the warrant requirements. Sufficiently describing the location. Let's say if it's a street, it has to have the address. If it has an address with multiple units, it has to say the unit on there. The key thing is to be as specific as possible about the place that you're going to conduct the search. The same concept applies to arrest warrant. The name of the person of a warrant, the name of a person is not sufficient. Not just the name, but the person must be particularly described in addition to the name. Because let's say somebody want to say they want to come to my house and they want to arrest Richard Wright. That won't be adequate because there's two of us here. There's Richard Wright Jr., and then there's me. But the person must be particularly described and include things like their first, middle, and last name, birth date, height, weight, sex, race, and other identifying factors that might narrow it to that individual. That's the key. So you get that point. So it's not like a carte blanche type thing. All right. So you narrow, it's very narrowly construed. The scope of the warrant refers to the boundaries or the extent of the authorized search. For example, the scope of the warrant for the burglary case that is I didn't go over mentioned above may be to search the residence for specific evidence relating to the burglary. If during the search for the burglary evidence, detectives locate evidence of narcotics, they cannot change the scope of the original warrant and start searching for more narcotics. Searching for narcotics would not be within the scope of the original warrant. That's very interesting, but that's the way it works. So once the item or person is seized or has been described, it must include an affidavit supporting those facts, and it's obtained from the investigative officer's reports. But it is obtained from the reports, but less detailed than the reports. Rather, it is written in chronological order and includes the content that would allow a judge to determine if probable cause exists. That's it. And then you can click on this and you'll see what a search warrant looks like. I'm not going to do that. So what are the time frames for warrants? Well, most search warrants have to be served within a period, and this is generally is 5 days. And yep, you got it, Brenda, 5 days. And that during that period, many jurisdictions says that if it's not executed within that date, then they have to get another warrant. Now, here's something very interesting. When executing a search warrant, law enforcement officers must, did you hear me? Knock and announce before entry unless special circumstances exist. Now, you know, based upon the Breonna Taylor case, and maybe even the case that happened up in Minnesota, but the Breonna Taylor case, the no-knock warrant is under a severe attack. And I haven't been a police officer when there were no-knock warrants. I always thought that they were dangerous, not just to the people, but to the law enforcement as well. And so when you have a no-knock warrant, it doesn't require announcement, but it's extremely dangerous. And so because of the Breonna Taylor case, which everybody should be familiar with, the no-knock warrant issue has been under severe attack, and many departments have, as they say, very limited opportunities to use no knock. I mean, it's so limited that it's almost not used and considered at all. So it's dangerous, to be honest, for everybody. So moving on, once executed, a copy of the search warrant is left with the owner or the occupant. If nobody's there, a copy must be left at the location. And that's what some jurisdictions have, such as Tennessee has. So here's the key thing is that as we wrap this up, is that complying with the Fourth Amendment, search and seizure requires law enforcement officers to describe the places and things to be seized and must be supported by an affidavit based upon probable cause. Ideally, the courts would like to see a search or arrest warrant for every occasion, but not practical. So you'll see while we talk about the exceptions in the next. And then these are some of the cases. Okay. We got about 10 more minutes here. All right. I'm going to come back to warrant key terms. Well, I'll just go over that pretty quickly because you'll see that you can go through. And this is a flashcard information. So you want to check it. And this is just to show you, I'm not going to, unreasonable search and seizures. It does not prohibit searches or seizures, but unreasonable search and seizures. So you go to the next card. Affidavit. Click on affidavit and so forth. So this is just a review of what we just went over. So you can go over that on your own. All right. Because I want to make sure that we get the exceptions covered, which you already should be aware of. So there are several exceptions to when a warrant does not have to be obtained. And the common Fourth Amendment exception applied to the Terry stop or stop and frisk, what we call search incident to an arrest, vehicle searches, consent searches, plain view, garbage, and then there's some other searches here as well. But let's talk about plain view first. It means what it says. Okay, you go in, just the person is able to seize obvious contraband if, that big if, that two letters, the police are legally present when the inadvertent observation is made. Being legally present is an important component. So they have to legally be there. So they must have reason to be there legally. All right, and then they can seize information. Now, three important elements about plain view are this, and it's common sense. Law enforcement must be legally present. The discovery is inadvertent. So you come in and you're there and you're there, and let's say you're there to question somebody, and you look on the table and you see some bags that appear to be weed. Do you have to get a warrant to get that? No, it's in plain view. Okay, and the items to be seized must be readily apparent or appear to be contraband. And that's pretty much what it is. And I'm not going to go over these fact patterns here because I want to make sure I get these others in. But that's the easiest one to see. Okay, let's say, for example, you stop a person, you see this person, they're reaching in the pocket to get something. Let's say, for example, if it was sticking out of the pocket without them touching it. All right. Would it be in plain view then? The answer is yes, it would be. Yeah, okay. Yeah, that's what I mean. And it means what it says. View. You have to be able to view it, but not do anything. Like, for example, tipping you off, not going into the refrigerator on the way to the bathroom and finding a head. You remember that one, Brenda? Okay. That's why, that says, oh, no, it was in plain view. Of course it was after you opened the man's refrigerator. Now, if you had asked the man, could I go in your refrigerator and get a drink? And he says no, then, you can't. Why can't I? No, you can't. You won't want to go there. Okay. Anyway, that's my point. Plain view means plain view. Consent. It must be granted by permission by the person who has authority to do so. It must be knowingly given and it must be voluntarily. So let's take a look at a situation where a person is being questioned and they're circled by police officers. And they go in and they just start looking for stuff without consent. No, that's not going to fly because it is not voluntarily given. Okay, so there's this case like Mendenhall, for example, is a case that Supreme Court examined if consent was voluntarily given when this woman was approached by DEA agents at the airport, and it was a suspicion if she was carrying narcotics, and the agents asked for her identification and questioned her about how long she had been in California, and she produced evidence. Well, agents um, also explained she had the right to refuse a search, but then if she agreed to it, then any evidence that they found could be used. Okay, so a person doesn't need to know they have the right to refuse consent. However, um, the key thing is that it must be voluntarily. So I guess it's kind of catch-22. So let's say if the consent is knowingly given, including the age to give consent, their level of education, intelligence, and stuff like that is all taken into consideration. The third element relates to a person's authority to grant consent. So a person granting consent must have the legal authority to do so. For example, the owner of a house may grant consent to search their home. The owner of a car may also grant consent to search their car. A person may consent to a search of their personal belongings themselves. Let me ask this question. In your house that you own, you have a person who rents a room from you. Can you give authority, can you give consent to search that person's room without a warrant? Okay, I'll answer it for you. Yeah, you're right. It's no. You can take that question mark off. It's no. It's no. Excuse me. The same thing would apply for your children, not minors, okay? But your adult children. I got two adult children living with me, okay? I got my 21-year-old, 22-year-old son, and I got my 27-year-old son. Well, he'll be 27 May 12th. Anyway, they both have their rooms, except they don't pay rent. So they're fair game, even though they're adults. But if they paid rent, then they would. So put them in the same category. Just a little something for you there. All right. Moving right along. You got the good old canine dog. I got a golden doodle. He should be a canine. That dog sniffs everything. My goodness. He's always sniffing, you know. He sniffs packages that come in. I guess if I got a bomb delivered to my house, the dog would let us know, you know. But anyway, then there's the automobile exception. Because automobiles are mobile. Um, yeah, they do that. Yeah. I call my dog a drug sniffing dog or whatever it is. I know he can sniff out some food, that's for sure. So anyway, a warrantless automobile search can occur with the consent, incident to a lawful arrest, or based upon plain view, plain smell. Um, and plain smell, as discussed above, comes about as well. In the case of Carroll versus United States, the Carroll doctrine permit law enforcement to search a motor vehicle. And the reason why primarily is because they're mobile and that it applies to passengers in the vehicle. Officer smells marijuana and so forth and so on. So the arrested person is unsecured and within reaching distance of the passenger compartment when a search takes place, or officers have an articulable belief that they find evidence uh, inside the automobile. Okay. There's no longer the blanket exception to search simply because of an arrest is made. Okay. Search incident to an arrest. So if a person is placed under arrest, you can search the immediate areas under control of that individual. That's the Chimo case established in 1969, and then extending to Mincy versus Arizona in 78. Both of those years I graduated. 69 from high school, 78 from law school. And so the Mincy court concluded the search of the Mincy's apartment was unreasonable and a court warrant should have been obtained. There is no crime scene exception to a warrant. So you see the effects that you might have. So in the Chimo case, the court came to the conclusion that if it was area that a person could destroy or reach, but the search of a dwelling instant to an arrest in the Mincy case says that Mincy exchanged gunfire while they had been investigating for selling heroin. The detective was killed. Mincy was paralyzed and arrested for homicide. Homicide detectives searched the apartment 4 days after, 4 days without a warrant. Can't do that. Okay. Finally, it's important to note that search incident to a lawful arrest does not permit law enforcement officers to lead an arrested person around a house, such as taking them to different rooms just so they can do that. You can't do that. All right. Then you have what we call parole searches, where if a person is on probation or parole, there are certain abilities to search them to keep them in compliance with the conditions of their parole or probation. Garbage. This is the last one. We're a minute or two over. If you throw something in the garbage, it's fair game. Your privacy, there is no reasonable expectation of privacy in garbage set out for collection, even if you do it accidentally. Warrantless garbage pulls, gosh, I don't get started on this. I remember one time I had an assignment and we had to go through somebody's garbage. I don't even want to think about it anymore. I don't want to think about it. But it was, we didn't even have masks on. You know, we wish we'd had masks back in those days to wear. But it was terrible. I can just simply tell you that it was, there were all kinds of things in that garbage can. Um, and when we got to the bottom of it, we found some stuff that caused that person to be arrested. So anyway, those are some of the exceptions. And then these are some of the cases. And then again, I supplied you with some as well. Okay, we did the exceptions to the search warrant, and then, you know, common Fourth Amendments. Then you can go over and you can, after you've done what we did, and you talk about these are all the ones that we covered. We didn't do the workplace and drug testing. People do have to do drops if they work in certain areas, and then drug testing. So you can be aware of those things as well. Okay. And then the knowledge check. You can do that on your own as well, like you did before. And you go begin. What, okay, let's just do one. Let me see if you can get this one. What is the level of proof needed for an arrest or search warrant? Come on. What is it? Okay. I just left it there. I wasn't saying that was it. But think about it. Yeah, it is probable cause. But this, not beyond a reasonable doubt, that's a standard for conviction. Reasonable suspicion, that's a Terry stop. So the answer is for a warrant, it's only leaves that one there. And so, yeah, you got it. All right. So you can go over these yourself. But so I wanted to uh, share that with you. All right. That's it for tonight. Do you have any questions? You're the official representative. You have any ideas that might fit? I have one in mind already. But you got it privately in here. Always put it so everyone can see it, but that's okay. What you want to make a suggestion? See if you're thinking like me. That's a scary thought if you do though, but okay. Want to type one? No guesses? Okay, I'll tell you. Touchdown. That is exactly, is it written up here? Does it say reasonable suspicion? That's it. It's reasonable suspicion. Very good, Brenda. But yes, reasonable suspicion. Write it out too, not shorten. Reasonable suspicion. All right. Thank you so much. That means you were focused in on what I was saying. I appreciate that. Uh, any questions or issues, please feel free to reach out to me, and I'll be happy to help you. You're welcome. I will look forward to seeing you guys again next Monday uh, for week number 4 as we continue to move forth and wrap up this course. Hope you're learning a lot about constitutional law. I enjoy teaching this course. So you guys enjoy your week. Take care of yourself. Stay safe. Man, we had some snow here in Chicago. I woke up this morning and I said, what the? We had an opening series with the White Sox, which they did win 2 out of 3. But they won more than 2 out. Really won 4 out of 6. So that was pretty good. But then it snowed. I said, well, maybe the Cubs are playing today. I can tell I'm a White Sox fan. That's that's pretty clear. All right. I'll see you next week. Good night. Okay.